Hello. Today my online presentation is about four question. What is a customary international law and what elements have to be shown for it to exist? Question number one. And question number two, what is the persistent objector principle? Discuss whether or not this principle is necessary or appropriate for developments in international law. Can a state be persistent objector to preemptory norms, just cogent of international law? Question number three, what is the relationship between a customary law and a treaty law, and what happens if there is a conflict between the two? What are the general principles of law and how do they operate as a source of law? Where do these principles come from? Question number one, what is the international law and what elements have to be shown for it to exist? Customary international law consists of rules that emerges from the consistent practice of a state and that are accepted as legally binding. It is one of the primary sources of international law as recognized in Article 38, Section 1b of Statute of International Court of Justice. For customary international law to exist, two key elements must be shown. Number one, state practice, which is called objective element. Number two, opinio juris, subjective element. State practice, this involves a consistent and general practice by state over time. The practice must be uniform, extensive, and continuous. Actions by a significant number of states must reflect similar behavior. Extensive, it should involve a representative number of states, including those particularly affected. Continuous, practice must occur with a reasonable frequency and regularity. Opinio juris, state must act out of sense of a legal obligation rather than convenience, habit, or political expediency. This distinguishes custom law from mere usage. For example, diplomatic immunity and prohibition of genocide. Diplomatic immunity, state consistently grant diplomatic immunity to foreign representatives, believing this is a legal obligation under a customary international law. Prohibition of genocide. Even before treaties like Genocide Convention, states refrained from genocide because they recognized it is a legal obligation stemming from customary law. What is the persistent objector principle? The question number two, the persistent objector principle allows a state to opt out of a rule of customary international law during its formation. If a state persistently and explicitly object to a rule while it is in development, it may not be bound by the rule, provided its objection is maintained and consistently over time. Real world example, for example, exemption for a customary law, United States and law of the sea. The U.S. persistently objected to the part of a customary international law related to the exclusive economic zone during its development. While most states accepted this provision as a custom, the U.S. maintained its objection before later adopting to a similar rule. Norway Fishery Case 1951. Norway successfully argued against the customary rule on maritime boundaries as it had consistently objected to applying a straight baseline before the rule became binding. Is this necessary or appropriate? Necessity. Necessity of persistent objective principle. It respects the sovereignty and consent of a state, which are the fundamental to international law. It prevents powerful states from unilaterally imposing norms on others. And appropriateness of general persistent objector principle. Critics argue that the principle undermines the universality and development of a consistent international norms. In practice, its application is very limited to protect the coherence of a customary international law. Can a state be a persistent objector to a preemptory norm, just cogent? No, a state cannot be a persistent objector to just cogent norms, which are preemptory and universal binding norms of international law. For example, prohibition on genocide, slavery, and torture. These norms are non-derogable and binds all the state, regardless of the consent of or objection. Question number 3. What is the relationship between a customary law and a treaty law? What happens if there is a conflict between the two? The relationship is based on two elements: complementary nature and interaction. Customary law and treaty law often coexist and reinforce each other. Treaty may codify existing customary law norms, and customary law can fill gaps left by treaties. Interaction. Customary norms can influence treaties' interpretation under Vienna Convention or Vienna Convention on Law of Treaties, Article 31 and 32. Conversely, treaties can crystallize or evolve customary law. And it has the conflict resolution is based on three principles: lex specialis principle, just cogent norms, and non-parties. Lex specialis principle: if a treaty and a customary rule conflicts, the treaty generally prevail for parties to the treaty. Just cogent norm: if a treaty conflicts with the just cogent norm, the treaty is void under Article 53 of Vienna Convention Law of Treaty. Non-party: customary law continue to apply to states not party to the treaty. Example of conflict between the treaty and customary law. Nicaragua and United States. International Court of Justice addressed whether customary law or a non-intervention applied. Despite U.S. not being party to the treaties like the UN Charter, the court affirmed that customary international law applied universally, even outside treaties. Treaty overriding custom. If later custom emerged that contradicted on earlier treaties, the environmental treaties superseded by evolving norms. The newer customary law can potentially override the treaty of for non-parties. Customary overriding treaty. Customary norms like the prohibition of torture prevail even over treaties that might allow it. For instance, no treaty's provision could justify torture as it violates just cogent norms. Question number 4. What are the general principles of law? How do they operate as a source of law? And where do these principles come from? General principles of law are fundamental legal principles recognized in domestic legal system across the world and applied to international legal context. They are a primary source of international law under Article 38, Section 1C of the International Court of Justice Statute. General principle of law operation. General principle fill gaps where neither treaty nor customary law provide guidance. They ensure fairness and equity in international law legal order. They are applied by court like International Court of Justice, interpret ambiguous provision or resolve dispute. And source of general principle of law are domestic legal system and judicial decision scholarly opinion. Domestic legal system commonly shared principle across legal tradition. For example, good faith, equity. Good faith applied in treaty negotiation and implementation. Example is nuclear test cases. Australia was France, 1974. International Court of Justice ruled that France was obligated to act in a good faith regarding its promise to halt nuclear tests. Equity. Courts often use equity to resolve territorial or maritime dispute. For example, North Sea Continental Shelf Case, 1969. International Court of Justice emphasized the equitable principle to determine maritime boundaries. Source number judicial decision and scholarly opinion. Courts, jurists help identify and apply this principle to international law. Thank you. Thank you for listening.